Good morning and a very warm welcome to our session number 1 in the Coffee Break Life Sciences Startup Series. This is a series of 12 sessions specifically tailored for life science startup companies, 1 session for each month in the year of 2024. And our goal is to provide you an overview over all interesting topics which should be taken into consideration when establishing a life sciences startup. Today it's the first session, and we will have a close look at confidentiality agreements and material transfer agreements. And yeah, I want to invite you to ask a lot of questions so that you get most out of the session. You can type your questions on the right side of the screen, and I'm happy to answer those during the session. We will also provide you with a set of the slides afterwards via email, so you do not need to take photos or write something about the content on the slides. As mentioned, we start with confidentiality agreements, look at them, why are they so important. I provide you with 5 most important tips and tricks for CDAs, and we'll have a look at further important contractual clauses in CDAs, and we do the same with material transfer agreements in the second part of the presentation. So let's start with confidentiality agreements. Other terms for confidentiality agreements are NDAs, that's non-disclosure agreement, or CDA is confidential disclosure agreement. So in any event, if you hear CDA, NDA, or confidentiality agreement, this means everything means the same, and it's all about the protection of your proprietary confidential information. So why are CDAs so important for life science startups? This is due to the fact that this is the only way you really can protect your proprietary information against uses which are not wanted, because normally in the very early stage of a life science startup, you have not protected your IP by IP rights. Probably patents have not been applied for, and therefore it's basically your know-how which you need to protect against unwanted uses, and this is by way of a CDA. What you should also think about is that if you are planning further financing rounds, that the investors will request to look into the CDAs in the course of their due diligence in order to get a feeling if you think about a good protection of your proprietary information, and therefore also in view of future financing rounds, it's important to have proper CDAs in place. And this means that really you should, in each occasion when you talk with third parties, may it be service providers, universities as potential cooperation partners, or only, for example, a COO or any party you are talking to, don't talk with them without having agreed on a CDA. General considerations when negotiating CDAs: there are 2 types of CDAs. one-way CDAs and two-way CDAs. The difference is that one-way CDA means that only one of the parties entering into the agreement will provide the information to the recipient, and in two-way CDAs there is an exchange of confidential information into two directions. So it's good to think about in the first place which type of CDA should be used. The one-way CDA for life science startups has the advantage that if you only provide information to third parties, that the life science company itself does not have any obligations for confidentiality, but it's only the recipient. So if it's one-sided and it's only you who provide the information, it's better to go for a one-way CDA, but often it's the case that the other party in some extent also provides confidential information, or it cannot be excluded that it's a two-sided relationship, and therefore often the other party will ask for a two-way CDA. Also, when starting negotiating CDAs, you should think about which template shall be used, because CDAs are always quite same in their form and content. Therefore, it's quite easy to use a template and to only amend it to the concrete situation. And here we would recommend that you really have one template for the one-way CDA and one template for the two-way CDA ready, and approach the other party and say that you have a template ready, and if they are fine with reviewing your one, because that makes it a little bit easier in negotiating the CDA, because you know your content, and it might be easier and quicker to sign it. Nevertheless, particular bigger pharma companies ask to use their CDA template, then you can also agree that you use their one, and you have, then you would need to review, make a markup to make sure that all provisions are acceptable for you, and then sign it. But default would be that you try to go with your template. Other question, which language to be chosen? We would recommend generally to go with the English language version, because that's really, I would say, market standard in the life science startup scene at the moment. However, particularly universities often say they need German universities particularly need German language versions, or probably also other universities their language version. This can also be done, and sometimes you would then need a bilingual version. For example, it's a French version and then the English version in one column and the French one in the other. That's also no problem, but these are all issues which you should consider before you enter into negotiating CDAs. Now we look at the 5 most important tips and tricks for CDAs. Starting in the left corner of the presentation with the parties. Basically, you would say parties, it's quite clear. It's your life sciences startup and the third party who shall provide information. But here there is already one consideration which you should make, because some of the third parties will ask to also include affiliates into the scope of the CDA, which means that the people who are allowed to receive the confidential information are a much higher number, and therefore you should carefully consider whether it's okay for your life sciences startup really to get the information disclosed also to all affiliates of, for example, a big pharma company. What you can do if the other party insists on including affiliates, you can include a limitation saying that only such affiliates and people of the third party may get the confidential information which have a need to know the information for the purpose. So this means a limitation that not everyone in the company and the affiliates gets the information, but only those who are really involved in the project. And therefore, that's the second point, the purpose. It's very important to limit the purpose of the confidentiality agreement to the limited, as limited as possible. So I would say the standard purpose for a CDA is to evaluate a potential collaboration with the third party, which means that the confidential obligation may only be used for this purpose, namely the evaluation of a future collaboration between the parties, which means that the other party will not be allowed to do anything else with the confidential information. Next point, definition of confidential information. Here it's very important to look that the definition is very broad in order to ensure that you really have all your proprietary information protected, which means that the ideal scenario would be that basically every piece of information you share is confidential, that it must not be marked as confidential, that also oral and visual information is covered. This would be the best case, because then it's clear that really everything what you share is confidential. But often the third parties come back and say they would need a narrower definition. This might be that the information must be marked as confidential, that each piece of information which has been shared orally has to be put into writing and things like that. This makes it a little bit tricky for you because, for example, if you have a telephone conference, you provide some information, then this would not fall under the CDA if you are not writing, if you don't write it down. Here, there would also be a tip to include at least a catch-all clause, which means that it would also be confidential information if a party which is familiar with the life science sector would consider such information confidential. That helps that at least you could you could argue that such person would have deemed such information confidential, and then it would also fall under the confidential information definition. That's a little bit more need to argue, and you would also have to prove this prerequisite, but at least it would be a possibility to make to ensure to protect your confidential information a little bit more than having a very narrow definition. Then the core provisions of the CDA are the confidentiality obligations. This means that the third party will only be allowed to use the information for the purpose. Therefore, as already mentioned, it's very important to define a very narrow purpose. And the other confidentiality obligation is that the recipient shall not provide or disclose the information to third parties. Another important clause is the term of the CDA. Here we recommend to have a term of the CDA only for the disclosure period. This is often quite short. For example, 1 year from signing. All information which is shared during this 1 year during the disclosure period would fall under the scope of the CDA. And then it's important to stipulate that the confidentiality obligations survive the term for a specific amount in time. For the life science startup, it's the best is to have a confidentiality obligation for as long as possible. So probably at first you could suggest 10 years. Often that's the other party will not accept that and go beyond, and I would say 3 years would be the absolute minimum to go. But it's important that you really distinguish between the disclosure period and the period for which the confidentiality obligation applies, because if you just say the term for the confidentiality agreement is 3 years, then it would be that if information is shared, for example, in year 2 and 11 months, then you would only have 1 more month for the confidentiality information to be protected, and therefore it's better to have 2 terms, 1 for the disclosure period and 1 for the confidentiality obligation. Further important clauses in CDAs, you should clarify that there is no warranty for the information provided for a specific purpose. That's important because, for example, if the other party wants to double check whether it makes sense to enter into a collaboration with you, and they say the data is not good enough and so on, it's important to say that there is no warranty in order to exclude any potential damage claims of the other party. Furthermore, it should be clarified that no licenses are granted under the CDA, so that it's really clear that the other party may only use the confidential information for the purpose and not for anything else. No obligation to enter into any further and future agreements, which means that you should also clarify that the CDA does not mean that there is any obligation to actually enter into the agreement to the later agreement, like a collaboration agreement or something, so that damage claims in this direction are also excluded. And other one is governing law and place of jurisdiction. Here we would go for German life science startups with German law as default, but sometimes if you have contracting partners from abroad, they will not agree on that, and then we would recommend to go for a neutral governing law. So in the best case, not to accept the governing law of the business place of the other party, but something neutral. For example, we always recommend going for the Netherlands. The advantage of the Netherlands is that the legal system is also a civil law legal system, quite similar to the German one. And the courts in Amsterdam have the possibility to do court hearings in the English language and file all statements in English. So you would not need to have any costs for interpretation, for interpreters, or for translation costs. Other neutral law is Swiss law, which is often chosen. That's also a good possibility. But court fees and attorney fees are normally higher in Switzerland. Therefore, we would recommend to avoiding this in the first instance, but it's also a good possibility. If the other party is a common law or is located in a common law state like UK or US, they often insist on that law. We are quite reluctant to accept this in bigger agreements, but probably in CDAs, where the likelihood that the case really goes to court is quite unusual. You could also think about going for or accepting US or UK law, but this is really the last resort and should only be the last possibility. So when entering into a CDA, or make sure that you enter into a CDA in each case before you disclose any information to a third party. Propose to use your template, and final check by a lawyer is always recommended in order to make sure that the points which I mentioned earlier are reflected in each case. Now, second part, we look at material transfer agreements. What is the subject of material transfer agreements here? The subject matter goes beyond the subject matter of a CDA as also proprietary material. So e.g. cell lines is provided to third parties. The provider, which is the life science startup company in our case, wants to restrict how the material is to be used. The provider also wishes to protect against any potential liability, particularly if the material is infectious, hazardous, or subject to special regulations. And of course, the provider wishes to obtain the results, the rights to the results, and the provider wishes to ensure that correct and appropriate acknowledgement is included in any publications. This leads us to the 5 most important issues for MTAs. Here again, in the right hand here, we have the purpose. Purpose means, again, that it's very important to clearly define for which type of work the material which is provided can be used by the third party. This is normally detailed in an annex, for example, a statement of work or an action plan. And here it should be described in detail which the other party is supposed to do, and which to be on the one hand sure that they do what they need to do, and on the other hand to not have a purpose which is too broad, because you provide material which is owned by you. So we are at the point ownership of material. The MTA should clearly state that the ownership of material remains with you, and that the receiver shall only use it for the purpose or for the project as described, and not for anything else. In connection with this, the IP clauses are very important in the MTAs. Here, in the first instance, you should try to get all results transferred to the life science company, so that you are the owner of all results and also of potential inventions. This would be the best case for you and should be the default, but often the other party says that at least it should be joint controllership. or that you only get a limited license for research purposes, and that further agreements like license agreements need to be entered into before using the results commercially. Often it's recommended to agree to such clauses in order to get the MTA done quite quickly, because MTA is also a very early stage agreement where it's not clear at all whether the results will be commercialized or not, and therefore I think in MTAs it's also okay to accept that you can only use the results for your internal purposes, and that for commercial purposes further agreements need to be entered into. Important is also that a clause is included that you are not liable for any damages because you provide the material. It might be hazardous or might have some safety issues, and then it's important to say that the user of the material has responsibility to use it, and if there are any damages that you are not responsible for those, but it's made clear that that lies within their responsibility. Costs, often you have a situation that there are no additional costs to be paid by either party, because you as the life science company provide the material for the other company, and the other company can use the results at least for their own commercial purposes. So there are no costs, but sometimes you can also agree on a fee for service, for example, if the experiments which are done under the MTA are quite time assuming, then it can also be agreed to make a payment for these services. But in any event, the MTA should include a provision. What about transportation costs for the material, and who needs to insure the material when transported to the other party? That would also be important. Quick look at other important clauses. Confidentiality, again, is very important in MTAs. Here, the same applies as already explained in the first part of the presentation. Nevertheless, the confidentiality agreement, the confidentiality provisions in an MTA are a little bit narrowed down, but contain also the most important fact that the information shall only be used for the purpose and not provided to third party. If the other party wants to make publications with the results, you need to make sure that you get a right to review the publication first, and particularly delete any information which you might need, for example, for a patent protection or patent application, because if such information would be in a publication, it would not be patentable anymore, and therefore it's very important that you ensure that the publication does not include anything what you might want to apply for a patent in the future. Other point is that the MTA should include a obligation of the other party to provide you with a report of the research they have done, and pay if a payment is required. You should at least make sure that a part of the payment will only be made after the report has been provided. Term is normally for the duration of the project and after the report has been provided. Governing law and place of jurisdiction is basically the same as already mentioned in the confidentiality section. That's the same, a little bit nicer in presentation. So we have already covered that. And now we have just conclusions for MTAs. MTAs are often entered into before starting a close cooperation, so e.g. for feasibility studies. And it's very important to have a clear and detailed description of the project and purpose. Yeah, I think that was exactly 30 minutes, and I'm looking at the questions, but I think there was no questions so far. Therefore, I hope everything was clear what I mentioned, and in any event, I'm available for any questions, or if you require a template or so on, you can contact me directly, and then I can announce the next date for section 2. That's on 21st of February, early stage IP strategy. My colleagues Anja Lunze and Tobias Baus from our patent department will then provide you with an overview of what you should think or what you should ensure in relation to IP strategy at this very early stage of life sciences startups. So thank you very much for joining us today, and have a nice day, and hopefully we keep in contact, and you also join us for the other sessions. Thank you very much.